This program is brought to you by Emory University.
If you're standing in the hallway, drinking coffee, eating pastry, stop immediately. Come inside. We're getting started, folks. The title of this next session is How Would States Apply the Children's Convention? And it's my pleasure and honor to serve as chair. My name is Michael Perry, and I teach here at Emory Law School. We have three speakers this morning, and the order in which they're going to proceed is a little bit different from the order of your program. The first speaker will be my colleague, Kimberly Jenkins. The second speaker, my colleague, Johan van de Wever, and then Mr. Howard Davidson. I'll introduce each of the speakers right before they speak. And I'm simply, you have the information about all the speakers over these 2 days here, but some of you may not have had a chance to look at it. So let me just tell you that Kimberly arrived at Emory Law School in the summer of 2004, so a little over a year ago, right? Just 1 year before I arrived here. So we're both relatively junior professors. She is a professor also at Emory Law School. She teaches civil procedure and education law. And unlike me, she has extensive litigation experience, in particular from her work at the Office of General Counsel of the United States Department of Education and the acclaimed law firm of Hogan and Hartson in Washington, D.C., where her focus was on race, sex, national origin, and disability discrimination in public schools and universities, as well as education finance. Kimberly served as articles editor for the Harvard Law Review and served as a law clerk for the Honorable James R. Browning of the United States Court of Appeals for the Ninth Circuit, who was actually a judge in the Ninth Circuit when I clerked in the Ninth Circuit a generation earlier. So he's an impressive guy. My pleasure to present Kimberly Jenkins.
As Michael mentioned, my name is Kimberly Jenkins, and I have the honor of serving as an assistant professor of law here at Emory University. I am grateful to have the opportunity to participate in this conference on the possible U.S. ratification of the Convention on the Rights of the Child, because I believe that actions that would bring our nation into compliance with the CRC would move our nation closer to the ideals that we profess, but unfortunately do not always live up to regarding equal educational opportunity. I found President Carter's reminder yesterday that totalitarian governments recognize the right to education and are able to eliminate illiteracy very encouraging as we consider the possibility of a U.S. right to education. Many other countries have committed to the effective education of their young, while the U.S. has thus far failed to make a similar commitment. Today, I will share some of my preliminary thoughts on the education articles in the CRC. The education articles cover a number of important issues in education, so I have decided to focus my remarks on the Article 28 requirement that states parties to the CRC must recognize the right of the child to education on the basis of equal opportunity, and the Article 29 provision that defines one of the goals of education as developing the child's personality, talents, and mental and physical abilities to her or his fullest potential. In examining these provisions and the potential avenues for U.S. ratification of these articles, I will propose answers to several questions. First, how has the committee that enforces the CRC interpreted these requirements? Second, what are some of the CRC's requirements that are different from U.S. law? And finally, how could the necessary changes to American education law be accomplished most effectively, including contrasting my proposed approach to how the U.S. should develop a federal right to education with how most other scholars have approached this issue. So how has the committee interpreted and implemented Articles 28 and 29? Article 28 delineates the content of the right to education that must be recognized with a view to achieving this right progressively and on the basis of equal opportunity. It requires states parties to make primary education compulsory and available free to all, to encourage the development of various forms of secondary education that are accessible to every child, and to offer higher education to all on the basis of capacity through appropriate means. Article 29 then establishes the goals of this right. Article 29 embraces a holistic approach in its requirement that education be directed to develop the child's mental and physical abilities, as well as the child's personality and talents to their fullest potential. The committee issues general comments that help to explain the CRC's requirements. The centrality of education to the CRC is suggested by the fact that the committee chose to issue its first general comment on the issue on the aims of education in Article 29. In this comment, the committee explains that education should ensure that students do not leave school without the essential life skills for confronting the challenges that they will experience in life. The committee leaves no room for ambiguity on whether the education articles require a quality education for all children by stating that, quote, every child has the right to receive an education of good quality, which in turn requires a focus on the quality of the learning environment, of teaching and learning processes and materials, and of learning outputs. The committee provides assistance in achieving these goals by encouraging states to take advantage of the technical assistance provided by the United Nations Children's Fund and other UN bodies. So what are the key differences between these CRC provisions on education and U.S. education law and policy, and how should those differences be addressed? The United States provides all children a primary and secondary education and is forbidden by the Supreme Court's decision in Plyler versus Doe from excluding illegal immigrant children and presumably any children from public schools except in disciplinary matters or exigent circumstances to protect the health and safety of other students. However, scholars have noted that a substantial obstacle to U.S. ratification of the CRC is that these opportunities not only must be provided, but there also must be a right to education that is achieved progressively and on the basis of equal opportunity. The U.S. Supreme Court in the 1972 decision of San Antonio Independent School District versus Rodriguez declined to find either an explicit or implicit right to education under the federal Constitution when a group of school children challenged the constitutionality of the financial disparities between Texas public school districts. The court held that the Texas finance system rationally furthered the legitimate state interests of local control of public schools. In light of this decision, most scholars recognize that the U.S. does not presently guarantee a right to education, and those examining potential U.S. ratification of the CRC acknowledge that this would pose an obstacle to ratification. Many scholars have called for the court to revisit this 5-4 decision in light of persistent disparities in educational opportunities and have suggested that the U.S. should recognize a right to education that embraces some level of basic skills. The focus of scholars on basic skills is a result of the Rodriguez decision, noting that the plaintiffs could not charge Texas with failing to provide them with an opportunity to acquire the basic minimal skills necessary for the enjoyment of the rights of speech and full participation in the political process. Scholars thus have pointed to this statement as a possible open door for recognizing a federal right to education to acquire at least these basic minimal skills. However, I do not think that the U.S. should consider adopting a right to education that focuses on basic skills, because it would not help our nation to fully develop the intellectual capacity of our children or to acquire the societal benefits that come from providing all children a quality education. Students need not only to be prepared to speak and vote, but also to obtain employment in an economy in which the skills acquired in high school education no longer result in a living wage. Instead, I think that the U.S. right to education should embrace the aim of the right to education in the CRC, that education should be directed to the development of the child's mental and physical abilities, personality, and talents to her or his fullest potential. Over the past 30 years, many states have been subject to school finance litigation that has required them to determine what it would take to provide all children with an adequate education, which is defined to encompass such goals as preparing students to be productive citizens. By recognizing a right to education that embraces developing children's mental and physical abilities to their fullest potential, states would be required to assess how best to achieve this goal while retaining the liberty to adopt different approaches. This type of right to education also would respect the expertise of state and local governments in education while recognizing that federal action has become necessary in the country's national interests to keep the U.S. from slipping further into mediocrity in academic outcomes and to overcome the educational inequities that have become deeply entrenched in American society. This federal right to education could be accomplished, among other ways, through spending legislation, which the Supreme Court has affirmed can be used to establish reasonable conditions on federal financial assistance for the general welfare. Such a right also could end a troubling practice that is often revealed in school finance litigation, in which legislators allocate to education the financial resources that are left over at the end of a legislative session, rather than undertake an honest assessment of what it would take to achieve certain standards. Furthermore, while I agree with many other scholars that ultimately the United States should recognize a right to education, I contend that the best approach for recognizing this right is not the approach recommended by most scholars, which is a right to education that would immediately operate as an enforceable constitutional or statutory right against each of the 50 states. Instead, I believe states should be required to provide a right to education on the basis of equal opportunity, but that this right should not include a private right of action against states or districts. The lack of availability of individual suits against states and districts would encourage a collaborative approach between the federal, state, and local governments to improve educational opportunities and outcomes. The implementation mechanism for this right to education would be modeled after the enforcement mechanisms for the right to education in international human rights agreements like the CRC. These implementation mechanisms adopt a reporting, public accountability, and technical assistance approach rather than a punitive or complaints-based approach. For example, under the CRC, the committee can recommend that states take advantage of technical assistance from UNICEF or others to address identified problems that prevent compliance. In this way, the committee enables states parties to undertake efforts to solve problems rather than simply criticizes them. The United States could follow a similar model and encourage states to obtain information from the government, universities, or educational organizations on best practices and successful educational reforms. In addition to offering and promoting technical assistance, the United States needs to go beyond the data collection and recording requirements of NCLB, the No Child Left Behind Act, that require districts to report disparities in academic outcomes along lines of poverty, race, ethnicity, disability, and limited English proficiency. States also should be required to provide accessible and easily digestible information on the disparities in educational opportunities that exist based on some of these same characteristics. This should operate to lay bare some of the causes of the disparities that are being revealed in the achievement data and encourage state and local action. I believe that this collaborative approach, rather than the complaints-based approach proposed by most scholars, would be the most effective first step in recognizing a right to the education in the United States for several reasons. First, as a practical matter, such an approach is the one that is most likely to result in adoption of a federal right to education in the United States. Education is one of the most closely held functions of state and local governments, and local control over education is viewed as an important virtue of the American education system. Actions that interfere with state and local control over education typically meet with intense resistance. Therefore, adopting an approach to a right to education that focuses on public reporting and technical assistance would make a federal right to education more palatable and less threatening to those people who would pose a more punitive, complaints-based approach. Second, a public reporting and technical assistance approach would build upon some of the current mechanisms in No Child Left Behind, which encourages providing the public with information on how well schools are performing and requires the breakdown of student achievement data based on a variety of student characteristics. These requirements assume that the public will exert pressure on schools and districts to implement effective changes and rely on several required changes if adequate yearly progress is not achieved overall or for a subgroup of students. While NCLB has met with substantial resistance, this resistance must be placed in the context of other protests to federal involvement in education, including protests that federal laws guaranteeing the rights of girls and disabled children were too intrusive, burdensome, or unnecessary. In other words, I believe that resistance to NCLB ultimately will give way to acceptance. In light of the substantial changes required by NCLB, an approach to a federal right to education that builds upon, rather than drastically deviates from, the current approach is more likely to be accepted by state and local governments and the American public. Furthermore, a collaborative and accountability-based approach could be viewed as a first step that could be followed by more demanding requirements. Subsequent efforts could build upon this approach and ultimately become more punitive if effective progress is not made in a timely manner. However, by adopting a cooperative and collaborative approach at the outset, the groundwork is established for a need to implement more coercive enforcement mechanisms if successful reform is not implemented. By establishing the goal of the right to education as the development of a child's mental and physical abilities to her or his fullest potential, a collaborative approach to a right to education would counteract some of the current negative incentives of the No Child Left Behind Act. NCLB currently includes a punitive approach to achieving high standards in which districts can lose financial assistance if they do not achieve adequate yearly progress. However, this has the perverse incentive of encouraging states to set achievement standards low to ensure that students can achieve these standards and thus avoid forfeiting any financial assistance. In contrast to this regime, by having each of the levels of government working together to foster the development of the abilities of all students, the nation could benefit from the elimination of the negative costs of failing to adequately educate our children. Ideally, the public reporting and technical assistance approach should be combined with substantial financial assistance to those states that are making good faith efforts to ensure that the right to education enables children to develop their intellectual, interpersonal, and physical abilities to their fullest potential. Such assistance would create incentives for reform and innovation, in contrast to a punitive approach, which oftentimes fosters resentment, resistance, and evasion. Furthermore, additional assistance would address one of the primary criticisms of NCLB, the lack of adequate funding to achieve its approach. In addition to recognizing a right to education, the United States would have to ensure that this right to education is provided in a manner that is neither intentionally discriminatory nor discriminatory in effect. While some scholars have concluded that the U.S. satisfies the non-discrimination requirements of the CRC, because the U.S. has laws that prohibit discrimination in education on a variety of bases, such as race, sex, and disability, these laws do not uniformly address and provide effective remedies for actions that have a discriminatory effect or that are the result of societal discrimination. In addition, the committee enforcing the CRC has not limited its prohibitions on discrimination to state actors or to governmental entities that receive federal financial assistance, as many of the U.S. constitutional and statutory prohibitions on discrimination are limited. Thus, the U.S. would have to expand the coverage of some of its discrimination laws to reach more private action, which could be made possible by U.S. ratification of the CRC. In light of my proposed changes and the increased federal involvement in education that they envision, at a time when we are at the high watermark of federal involvement in education, one could justifiably question the need for greater federal involvement in education. However, the federal government historically has acted to address national needs that local governments did not satisfy. In addition, the federal government has oftentimes intervened with legislation to protect the rights of the least powerful among us, including minority, poor, female, and disabled students, by prohibiting discrimination on the basis of these characteristics. Therefore, building upon the role of the government as the protector of those who are disadvantaged in some manner is not new in this country. I also believe that two concerns about the current state of U.S. education should encourage the nation to re-examine how it is providing educational opportunities, including whether we should provide a federal right to education. First, the United States currently has a declining or below average performance on international education comparisons with other industrialized nations. This fall, the Organization for Economic Cooperation and Development published a report that compares the education performance of many countries. The good news is that the United States compared favorably on several measures. For example, for 55 to 64-year-olds, the United States ranked first in both upper secondary education, that is secondary school from the age of 14, and in higher education, with 85% having completed upper secondary education and 35% having post-secondary education. And in addition, the United States also dominates international rankings of higher education institutions and is second only to Switzerland in its educational expenditures. However, the bad news for the United States educational performance is unsettling for the future of our nation. For 15-year-olds, the United States ranks 21st in mathematics and well below the OECD mean, with rankings trailing many European countries. 15-year-olds similarly scored poorly in problem solving, with the US ranking 23rd on this measure, well behind such countries as Japan, Korea, and Finland. In reading literacy, the United States had an average performance for 15-year-olds. While the US had a relatively large percent of its 15-year-olds achieving at the highest level, its overall performance was pulled down by the relatively high proportion of poor performers. This demonstrates that we have wide disparities in achievement in our nation. Even at the highest levels of achievement, the US had only 10% of its students, which is below the OECD average of 13% at the highest levels, while Belgium, Canada, Finland, Japan, Korea, the Netherlands, New Zealand, and Switzerland had twice the US percentage of students at the highest levels of math and problem solving. In addition to our declining and poor performance on international education comparisons, the provision of inferior educational opportunities for poor, urban, and minority children is for too many an accepted part of the American educational landscape. Even a casual comparison of the educational opportunities provided to inner-city, low-income, and non-white students reveals inferior facilities, fewer in-class educational resources, and larger class sizes. Jonathan Kozol documents this troubling phenomenon in his recent book, The Shame of the Nation, The Restoration of Apartheid Schooling in America, in which he describes the current disparities in educational opportunity as a national horror in plain view. In this book, he describes schools in the United States that are lacking in the basics, such as clean classrooms and bathrooms, current textbooks in good condition, and necessary laboratory supplies. He further notes the lower expenditures of many minority and low-income urban centers in contrast to the white surrounding suburbs. For example, 80% of the students in Chicago are minority students and 85% are low income, and that district spends $8,482 per pupil. In contrast, the 90% white and 8% low income Highland Park and Deerfield School District spends $17,291 per pupil. Data from the Education Trust confirms that this is not an isolated example. In 31 states, districts with the fewest minority children receive more funding per pupil than districts with the highest percentage of minority students. Similarly, the districts with the least child poverty receive the most funding, while the districts with the most child poverty receive the least. In addition, the U.S. is ranked 23rd out of 29 countries on whether it allows the socioeconomic background of students to influence academic performance in math, which indicates that 22 countries were more effective than the U.S. at minimizing the influence of students' socioeconomic background on achievement. In conclusion, I believe that efforts to ratify the CRC could usher in conversations about the persistent denial of quality educational opportunities for many children that would benefit both children and our nation. The words of another great president, John F. Kennedy, are instructive on the importance of this effort. He said, "Our progress as a nation can be no swifter than our progress in education." And so it remains that education is central to the future direction of our nation. However, too often we have sacrificed many children, particularly disadvantaged, minority, and urban children, at the altar of federalism and local control. But this need not remain true for the next generation. U.S. ratification of the CRC can serve as one impetus for a long overdue change in American education policy that recognizes that every child has a federal right to an education that seeks to develop the child's mental and physical abilities to her or his fullest potential. This right also must embrace the eradication of policies that are not only intentionally discriminatory, but also are discriminatory in effect. The recognition of this right could be one example of what is right with children's rights. Thank you.
Thank you, Kimberly. Our next speaker, another of my colleagues, Professor Johan van te Vever, is the I.T. Cohen Professor of International Law and Human Rights at Emory University. Formerly a professor of law at the University of, I'm not going to pronounce this right, Witwatersrand, Johannesburg, South Africa. Johan is an expert on human rights jurisprudence and the International Criminal Court, and actively participated in efforts to end apartheid and bring constitutional and human rights reforms to his native South Africa. Professor van te Vever also has served as a fellow in the Human Rights Program of the Carter Center and is the author of several books in Afrikaans and English, including The Protection of Human Rights in South Africa and more than 300 articles. Johan.
The Convention on the Rights of the Child places all kinds of obligations on states parties to the Convention to ensure its effective implementation at the municipal level. Recognize the inherent right to life of every child and ensure to a maximum extent possible the survival and development of the child. Implement the right from birth of a child to a name and nationality. Combat the illicit transfer and non-return of children from abroad. Respect the rights of the child to freedom of thought, conscience, and religion. Ensure the access of children to information. Protect the child against all forms of physical violence, injury, or abuse, neglect or negligent treatment, maltreatment or exploitation, from economic exploitation, and from all forms of sexual abuse. Secure access of all children to health care services, and a standard of living adequate for the child's physical, mental, spiritual, moral, and social development. Provide compulsory primary education free of charge to all children, and make secondary education available on the basis of capacity by every appropriate means, and much, much more. The Convention proclaims, most importantly, that in all of this, the best interest of the child shall be a primary consideration. In my written essay, I deal with 4 themes. The one is the right to equality and non-discrimination. Second, the question of juvenile justice. Thirdly, the religious rights of the child. And finally, the enforcement of those rights. I deal with it in a comparative way, comparing how these matters are dealt with in the United States with how it is dealt with in South Africa. I will probably only have time to read an extract from the non-discrimination issue, and I'm going to eliminate all my references to South African law because of time constraints, not because I'm ashamed of South Africa. The CRC right at the outset instructs states parties to respect and ensure the rights set forth in the Convention to each child without discrimination of any kind, irrespective of the child's or his or her parents or legal guardian's race, color, sex, language, religion, political or other opinion, national, ethnic or social origin, property, disability, birth, and other status. Several states parties experienced problems with the generality of the non-discrimination decree and added reservations pertinent to this provision. Reservations entered by the Bahamas and Cook Islands were based on fears that the provision might imply the conferment of nationality of those countries upon a child who does not otherwise qualify for citizenship. Belgium entered a declaration stating that non-discrimination on grounds of national origin must not be taken to imply the obligation for states automatically to guarantee to foreigners the same rights as to their nationals. Perhaps more telling were declarations and reservations attached to the instruments of ratification of a large number of Muslim states, mostly couched in general and sweeping terms, seeking to exclude the binding effect of all provisions in the CRC that are incompatible with the laws of Islamic Sharia. Several European countries, including Austria, Denmark, Finland, Germany, Ireland, Italy, the Netherlands, Norway, Portugal, Slovakia, and Sweden, lodged objections to these reservations because they, or some of them, were either too general and unspecified or were seen to constitute violations of Article 19 of the Vienna Convention on the Law of Treaties, which precludes reservations incompatible with the object and purposes of the treaty. The Syrian Arab Republic was slightly more specific in drafting its reservations to CRC provisions. It protested those provisions which are not in conformity with the Syrian Arab legislation and with the Islamic Sharia principles, in particularly the content of Article 14 relating to the right of the child to freedom of religion, and Articles 20 and 21 concerning adoption. Germany, among others, on September 21, 1994, objected to the reservation owing to its indefinite nature, and Syria subsequently deposited a communication with the Secretary General of the United Nations explaining its reservation in more detail. Syrian law does not recognize the system of adoption, and its reservations to Articles 20 and 21 means that approval of the Convention should not in any way be interpreted as recognizing or permitting the system of adoption to which reference is made in those articles. And its reservation to Article 14 of the Convention applies only to religion and do not concern those relating to thought and conscience. For the most part, though, one is left in the dark by the declarations and reservations of predominantly Muslim states as to the impact of Islamic law on specific provisions regulating the different rights of the child, including the principle of non-discrimination fundamental to the protection of all those rights. The principle of non-discrimination was may especially be implicated in plural societies that include diverse ethnic populations. Canada entered a reservation to Article 21, which deals with adoption, to fully accommodate customary forms of care among Aboriginal peoples in Canada, and in a statement of understanding interpreted its obligation to take legislative, administrative, or other measures to implement the rights enunciated in CRC as mandated by Article 4, to be conditioned by the right to self-determination of ethnic, religious, and linguistic minorities or peoples of indigenous origin. Pluralistic arrangements to accommodate indigenous laws and practices of Aborigines probably also prompted a reservation by New Zealand to continue to distinguish as it considers appropriate in its laws and practice between persons according to the nature of their authority to be in New Zealand. As will appear more fully from the later paragraphs in this written essay, international law proceeds on the presupposition that a child's interests are best served within a family environment and under parental care and control. Admittedly, domestic practices within the family circle are to a large extent based on traditions determined by ethnic or religious association. That too must be respected by the repositories of political power. A salient principle of contemporary international law thus proclaims the right to self-determination of peoples. And peoples, the beneficiaries of this right, have been identified as national or ethnic, religious, or linguistic minorities within a political society. Article 30 of the CRC affords to children also the right to self-determination as defined in international law. France and Turkey entered reservations to this provision, seemingly prompted by a certain animosity toward sectional group formation within those respective countries. Oman entered a reservation to record its position denying a child the right to profess his own religion or belief. The right to self-determination of cultural or ethnic, religious, and linguistic communities as defined in international law is subject to limitations. At the international level, the United Nations Declaration on the Rights of Persons Belonging to National or Ethnic, Religious, or Linguistic Minorities excludes the right to self-determination of such communities that violate the national laws of a country and are contrary to international standards. Current state practice does not uphold the limitations inherent in the right to self-determination of social communities dictated by the international standards criterion to the letter. For example, gender discrimination is condemned in almost all of the international human rights conventions and covenants, yet religious institutions that discriminate against women on gender grounds have thus far successfully claimed a right to conduct their internal affairs within the sphere of their own internal household according to the dictates of their faith. And perhaps rightly so. Does one really want the state to compel the Roman Catholic Church and others to ordain women as priests or as part of their clergy? The practice of female genital mutilation, on the other hand, cannot be justified on basis of the right to self-determination of peoples. This raises the question as to the appropriate criterion for separating those violations of international rights standards that do and those that do not exceed the limits of the right to self-determination. There are no clear answers to this question. It would seem, though, that those customs and traditions of a social community that threaten the life or violate the physical integrity of members of the group will clearly not be tolerated under the pretenses of the right to self-determination. The United States, too, harbors religious and indigenous groups that have by and large upheld the right to self-determination of such groups. In 1998, the United Nations Special Rapporteur on Religious Freedom, Professor Emory of Tunisia, conducted an informal investigation in the United States into compliance in this country with the subject matter of his brief. Although the state of religious freedom in the United States is by and large satisfactory, the Special Rapporteur found causes for concern in this regard in respect of members of the Arab community being singled out for special scrutiny at airports, and this was before September 11th, and insensitivity of the American authorities to the spiritual values of Native Americans, and the latter one only is a question of self-determination. Ratification of the CRC by the United States would have more serious equal protection and non-discrimination repercussions in quite a different context. On December 16, 1977, a juvenile Terry Roach was sentenced to death by a criminal court in South Carolina for the rape and murder of a 14-year-old girl and the murder of her 17-year-old boyfriend. And at more or less the same time, another juvenile, Jay Pinkerton, was sentenced to death in Texas on charges of murder and attempted murder. Roach and Pinkerton were both 17 years old at the time the crimes were committed. Complaints were lodged on their behalf before the Inter-American Commission of Human Rights, based on the submission that the execution of persons who were juveniles at the time the offense was committed violated the American Declarations on the Rights and Duties of Man of 1948. The Commission concluded at the time that there was a rule of international law which, with the force of jus cogens, applying to member states of the Organization of American States, which prohibits the execution of children. However, the Commission was convinced by the United States that there does not now exist a norm of customary international law establishing 18 to be the minimum age for the imposition of the death penalty, though the Commission opined that such a rule was in effect emerging. But the Commission went on to hold that the arrangements in the United States as to juvenile executions violated the norm of equal justice for all as laid down in Article 2 of the Declaration. The different arrangements applying in the states of the United States in regard to the death penalty was the basis of this finding. Those arguments make imposition of the death penalty for the same crime dependent on the place where the crime was committed, with perhaps only the side of a river where the act took place as the fortuitous divide between a penalty of life or death. The Commission summarized its views as follows, and I quote, "For the federal government of the United States to leave the issue of the application of the death penalty to juveniles to the discretion of state officials results in a patchwork scheme of legislation which makes the severity of the punishment dependent not primarily on the nature of the crime committed, but on the location where it was committed. Ceding to state legislatures the determination of whether a juvenile may be executed is not of the same category as granting states the discretion to determine the age of majority for purposes of purchasing alcoholic beverages or consenting to matrimony. The failure of the federal government to preempt the states as regards this most fundamental right, the right to life, results in a pattern of legislative arbitrariness throughout the United States, which results in arbitrary deprivation of life and inequality before the law, contrary to the provisions of the Declaration. The Commission subsequently found that a rule of customary law has in the meantime been established pinpointing the age upon which a person may be exposed to the death penalty at 18 years. And as everyone knows, the US Supreme Court has recently, in the case of Roper versus Simmons, decided that sentencing a person to death for a crime committed while the perpetrator was under the age of 18 years is unconstitutional in the United States. Roper represents a giant step forward in bringing the American criminal justice system up to the international standards of justice, but does not resolve the equal protection non-discrimination dilemma that still remains an obstacle to ratification by the United States of the CRC. The great diversity at the state level of rules regulating the prosecution of juveniles for serious crimes as though they were adults may be cited in this regard. The problem confronting the United States derives from the fact that its Federal Bill of Rights has been confined to the protection of civil rights only, to the exclusion of the most fundamental natural rights of the individual, such as the right to life and the right to human dignity. Legal aspects of these rights can be regulated almost at will by the state legislatures. The American federal system, and more precisely the sovereign power of states, are commonly held out as an excuse for inequalities in the protection of the law afforded in regard to some of the most fundamental human rights. But in international law, the United States constitutes a single entity, and it's consequently required to uphold the customary law norm of equal protection in regard to all fundamental rights and freedoms within its entire territorial domain. The US Supreme Court indeed possesses wide powers to read those fundamental rights and freedoms into the general language of the Bill of Rights, as most recently evidenced by the judgment in Roper. The federal legislature, on the other hand, cannot to the same extent impose uniformity on the whole country in matters within the exclusive jurisdiction of the states. Ratification of the CRC by the United States is therefore exclusively, so it would seem, dependent on intervention by the US Supreme Court to recognize and to proclaim the inherent injustices of institutions that differentiate and discriminate against juveniles on a state-specific regional basis. The United States, as a matter of course, invariably add a so-called federalism clause to its instruments of ratification of human rights treaties, leaving implementation of matters within the jurisdiction of states exclusively to state legislatures. In the present context, a federalism reservation would not be advisable. The CRC provision demanding of states parties to take measures to secure the rights enumerated in the CRC to each child within its jurisdiction without discrimination of any kind is so fundamental to the entire convention that a ratification seeking to exclude this demand would most certainly be incompatible with the objects and purposes of the CRC and thus fall foul of the Vienna Convention on the Law of Treaties. Allow me just from the section on juvenile justice to refer to two cases, if I still have time. Yeah. In September 2002, a 12-year-old South African girl prevailed on two strangers to kill her grandmother, a businesswoman of Pietermaritzburg, the city where I was born, with whom the girl was staying at the time. Those two strangers were each sentenced to 25 years imprisonment for the murder of the grandmother, Mrs. Govender. Thereafter, the girl was brought to trial. It was in March of this year. In sentencing her, Justice Swain considered the options: imprisonment, correctional supervision, and home-based supervision. He decided on the latter course. Sentencing her was postponed for 36 months. For that period, she was placed under house arrest in the care and custody of her mother and subject to stringent conditions. She was to continue with her secondary school education. She was then 14 years old and in the 9th grade, and was to be permitted to participate in school activities. She had to attend a program of the National Institute for Crime Prevention and Rehabilitation of Offenders, focused on life skills and therapeutic courses, and undergo regular support therapy. And she had to render 120 hours per year of community service. A correctional officer was requested to visit her at least 4 times per week and to ensure compliance with the terms of the accused confinement and to submit quarterly reports to the court. The court chose this course of action based on the best interest of the child criterion, in terms of which emphasis in the sentencing of juvenile offenders must always be on rehabilitation rather than on deterrence or prevention, and their reintegration into society. The South African Constitution underscores this approach by providing that every child has the right not to be detained except as a measure of last resort. And then there's a page missing. But let me just tell you that I compare this with a case which occurred practically at the same time. I think the judgment was in the same month, in March of this year. It was a 12-year-old boy in South Carolina who killed his 2 grandparents. And he was then sentenced to 60 years imprisonment. He was prosecuted as though he were an adult, and the personal circumstances of the child was presumably not taken into account by the court. The fact of his diminished culpability counted for nothing because he was prosecuted as an adult. I might just add that, that when he appealed against his judgment, which was denied, the court referred to other recent cases in South Carolina where a 13-year-old child was sentenced to 100 years in prison without parole, a 15-year-old to life without parole, 14 and 15 juveniles to 91.5 years imprisonment, a 13-year-old to mandatory life imprisonment, a 16-year-old to life imprisonment plus 60 years, and a 15-year-old again to life without parole. The practice of trying a juvenile as an adult emphasizes in the penal policy of the United States the nature of the crime and not so much the culpability of the accused. The institution of minimum sentences for juvenile offenders and the age upon which juveniles are treated as adults for purposes of detention constitute elements of the American criminal justice system which are at odds with international standards. All the states of the United States make provision for prosecuting juveniles as adults. Different rules apply in different states as to the offenses for which this can be done, the procedure to be followed in each case, and the age upon which a child may be prosecuted as an adult. At the end of 2002, altogether 23 states, including South Carolina, had no minimum age upon which a juvenile could be transferred for trial from a juvenile court to a regular criminal court, while in other states the minimum age that applies in this regard ranges between the age of 10 and 15. The most common age restriction for trying a juvenile as an adult is 14. But in states such as Indiana, South Carolina, and Vermont, the minimum age is as low as 10 years. A decision to try a juvenile offender as an adult is almost exclusively based on the nature of the crime and in disregard of the reduced culpability of the accused. If a juvenile is tried as an adult, it is accepted without further ado that he or she possesses the same capability to form a criminal intent as an adult. And minimum sentences applying to adult offenders will mostly also be imposed. Although accountability is supposed to count for something when it comes to sentencing the juvenile prosecuted as an adult, in actual practice, this in many cases seems to be a fiction rather than truth, because he then gets the minimum sentence applicable to adults. And I'll call it a day at that. Thank you.
Kimberly, Johan, and I are all members of the Emory Law Faculty. The Emory community now has the pleasure of welcoming to the podium someone from beyond the Emory community, Howard Davidson, who is the director of the American Bar Association's Center on Children and the Law, where for more than 26 years he has been responsible for nationwide activities related to children and the legal system. Mr. Davidson directs a large staff of attorneys and social scientists engaged in consulting, technical assistance, training, and writing projects on many legal topics. These have included children in the courts, legal representation issues, children's legal rights, child protection-related legislative reforms, parental rights and responsibility laws, domestic violence and its impact on children, child sexual abuse, family preservation, foster care, and legal permanency, parental kidnapping of children, child pornography and prostitution, adoption, legal planning for parents with HIV/AIDS, and a range of child-adolescent health law issues. Mr. Davidson and his staff provide consultation to courts, attorneys, organizations, and other professionals across the country on child welfare and child protection legal issues. And I noticed that Mr. Davidson and one of our other speakers at this two-day session, Cynthia Price-Cohen, are the co-editors of the book Children's Rights in America, UN Convention on the Rights of the Child Compared with United States Law. So it's a great pleasure to welcome Howard Davidson to the podium. Thank you.
Thank you very much. You've already heard that American critics of the Convention on the Rights of the Child have galvanized opposition among their followers by mislabeling it as a threat to the American family and making unsubstantiated claims it would undermine our national sovereignty and interfere with American parent-child relationships. And you'll hear more about that this afternoon. I want us to put those untruths aside and refocus the argument on why it is important for the U.S. to ratify the CRC. One good reason, of course, is that the U.S. can then become a world leader in promoting national laws and government policies that can help protect children from violence and unsafe care. That is something we have a great deal of expertise on. A few weeks ago, as I began to consider how I would talk to you about the CRC's potential impact in the U.S. and the status of children's rights within our country, I was asked by an American Bar Association international program to review and comment on a draft children's rights code for the nation of Kyrgyzstan. I was impressed with the breadth of that draft law, with its sweeping articulation of the rights of their children in accordance with the principles of the CRC. I couldn't help but think that in my 30-plus years in the child protection law field, I had, despite the draft's many flaws, never seen any U.S. federal or state law remotely like it. If we were to ratify the CRC, we would, I am convinced, likely see new legal protections for children that would, as with many U.S. child protection law reforms, have broad bipartisan support. We now have 50-plus years of isolated judicial decisions that address children's constitutional protections applied to limited fact situations. They include, of course, protection from juvenile incarceration without access to legal counsel and the ability of students to express political views in non-disruptive ways. The court decisions also address the protection of children in foster care, and more recently, curtailment of the juvenile death penalty. In the legislative arena, we have universal free K through 12 education and model federal and state special education laws. And more states, like Georgia, have created child advocate offices or children's ombudsman programs to oversee and to provide a mechanism when the system is not working. However, in no way do we have the vast body of American children's rights law that the CRC encourages. We are, however, doing many things right, and we need to build United States support on the CRC on our achievements. One of the most important reforms in U.S. law as it relates to children has been a focus on what CRC Articles 19 and 34 refer to as protection rights of children, both at home and in the foster care system. U.S. legal advancements in child protection, although we still have far to go, is one reason why the Bush administration was comfortable in so quickly ratifying the optional protocol to the Bush administration was so comfortable in urging the ratification, and the U.S. Senate in ratifying the optional protocol to the CRC on the sexual exploitation of children. We must, as part of our CRC strategy in the U.S., build on the Republican Party's support for aggressive legal protection for trafficked, exploited, abducted, and seriously abused children. American child advocates have much to be proud of. Attorneys advocating for foster children's rights to protection have won victory after victory, exemplified by the 2003 Washington State Supreme Court's decision in Brom versus State. Brom cited over 20 years of federal court precedents affirming that foster children possess substantive due process rights under the U.S. Constitution that states are required to respect. Those rights include the right to be free from unreasonable risks of harm and a right to reasonable safety, including adequate services to meet a foster child's basic needs. Despite these judicial victories for children, our statutory research only found, with one notable exception, narrowly tailored rights-based state laws for children. These children's rights laws are almost entirely found in limited, albeit important areas that actually are recognized by the CRC. For example, these laws include the rights of children in foster care placement, such as in New Jersey, Rhode Island, and one currently pending in Pennsylvania. They also include legislative protection of the rights of child crime victims, as in Illinois. I helped the International Bureau for Children's Rights draft international guidelines on this subject, and these were recently approved by the United Nations. By ratifying the CRC's optional protocol addressing child prostitution and pornography, the U.S. has already obligated itself to, quote, adopt appropriate measures to protect the rights and interests of child victims, unquote, at all stages of the criminal justice process. The CRC itself contains similar obligations that it shouldn't be so hard for the United States to accept. An exception to the more subject-limited statutes is a broad law in the Commonwealth of Puerto Rico. Puerto Rico's Bill of Rights of the Child, enacted 7 years ago, covers persons from birth through age 21. It explicitly guarantees to children and youth the enforcement of their rights in a vast array of areas protected under Puerto Rico's Constitution, laws, and policies. Its 27 provisions, not surprisingly, track many CRC topic areas. No state law is anything like this. How important is it to articulate rights of children in statute? Well, here's one example. New Jersey's law on the rights of children placed outside of the home, enacted in 1991, 6 months ago became the basis of an important federal court decision. Judge Brotman of the U.S. District Court for the District of New Jersey held that children maltreated in an adoptive home not only had a federal constitutional claim for deprivation of their substantive and procedural due process rights, but also a private right of action for damages under that specific New Jersey law. The court deemed it important that the law gave children placed by the state outside their home rights independent of their parents. We need more laws like those in Puerto Rico, Illinois, Rhode Island, and New Jersey. States, as well as the federal government, should be increasingly guided by laws that can be used to evaluate policies and practices of government agencies, as well as court involvement with families. Laws should also be used to measure whether government is fulfilling its obligation to promote the healthy development of children, free of violence in their homes and in their neighborhoods. Americans need to learn that the CRC encourages that. Prior to Justice Kennedy taking note of the CRC in the Roper versus Simmons case, Very few federal or state judges had ever cited the CRC or applied it within a child-related decision. We've found only 19 American cases since 1989, mostly federal, where the CRC has been originally cited. The only CRC citation we could find in a reported trial-level decision was in Ohio in support of a best interests of the child-oriented decision. In what I'm sure the judge saw as giving a child, quote, a breath of fresh air, unquote, that's my quotes, the judge included the CRC among voluminous citations to the best interest standard, and he used the best interest standard and the CRC to support his decision to bar both parents in a child custody suit from smoking in the presence of their child. Of the 19 CRC court citations we found, most have been cases involving immigration-related asylum claims within the U.S. In only 2 of those cases was there a suggestion that the CRC should be a guiding or controlling factor in the dispute. But in both, the CRC was cited in the dissenting opinion for an unsuccessful asylum seeker. All this tells me is that we need to do much more work educating American judges and American lawyers about what the CRC is all about. Except for a key citation in the Roper decision, the CRC has had little American judicial impact. Likewise, individual children's rights laws at the state or federal level have had very limited impact on government actions. This should not be surprising in that I contend that there is no children's rights movement in our country within the executive, legislative, or judicial branches of government, or among lawyers like myself who spend all our time addressing child law issues. In various ways in his new book, What's Wrong with Children's Rights, which Marty didn't bring, but I did, Professor Guggenheim criticizes both children's rights advocates and what he calls the children's rights movement. In reality, there are few legal professionals I know who would say their work focuses on advancing children's rights, as distinguished from protecting children from harm. The ranks of self-proclaimed American children's rights advocates are actually few. For example, a Connecticut judge has for years single-handedly led a personal campaign for a children's rights amendment to the United States Constitution, but I know of no significant legal support for his work. The national campaign to promote U.S. ratification of the Children's Rights Convention, which, as you've heard yesterday, is planning a national summit next year to garner support for ratification, is operating with very little money. I can only think of 2 American programs that have children's rights in their name. One is Children's Rights, Inc., based in New York City. Its work is focused on but one important area of rights, the protection and services due children who are victims of parental abuse or neglect and who enter the foster care system. The other is the Children's Rights Council, based in Washington, D.C. Its name is somewhat of a misnomer in that it principally advocates for non-custodial parents to have greater access to their children. It also promotes the legal concept recognized in Article 9 of the Convention that children have the right of active involvement of both parents when they are separated or have been divorced. In devoting no more than 8 sentences of a 300-page book to the CRC, Professor Guggenheim is not alone among practicing lawyers, law professors, and children's advocacy organizations in ignoring how the convention might positively affect our country, although I was very pleased to hear him talk about the convention this morning. One won't find detailed information about or advocacy for the CRC on the websites of the Children's Defense Fund, Child Welfare League of America, Voices for America's Children, or any of the country's leading national child advocacy organizations. Yet, the 3 organizations I just mentioned are advocating for the large systemic reforms that Marty says children's rights advocates are failing to push for. I am proud that the ABA was both an early supporter of the U.S. ratification of the convention and that Cynthia and I produced, as was mentioned, the first U.S. book on the convention titled Children's Rights in America. Although prior to yesterday I'd never spoken with Marty about the CRC, I would suspect that Professor Guggenheim's chief criticisms of the convention would be that it gives too much weight to best interests of the child as a factor in government decisions. He's called the best interest decision-making factor, quote, a formula for unleashing state power without any meaningful reassurance of advancing children's interests, unquote. I don't have time to detail why I so strongly disagree, but I believe that the best interest of the child, as well as the CRC itself, when guided by wise legislative and policy direction, is not incompatible with support for parental authority that respects children's dignity and safety. I must note that the CRC both promotes the best interests of the child and supports and gives great deference to parental decision-making prerogatives. To the extent the CRC addresses, as it does in several articles, intrafamilial child custody conflict, I want to respond to Marty's observation in his book that child custody cases are, quote, not really about children, unquote. He says they are really about the interests of adults. Like it or not, whether treated as parties in interest or not, children are in the eye of the hurricane of such disputes. The CRC can be a vehicle to help support policies that will help better assure that their voices are heard in bitter family wars. As Professor Guggenheim has noted, one key aspect of the legal status of children is their access to legal counsel when involved with the courts and having their voices heard. I've been working for a year now with the National Conference of Commissioners on Uniform State Laws on the drafting of a model state law on legal representation of children. The commissioners are calling for something that only slightly more than half our states now require. Every child subject to an abuse and neglect-related judicial proceeding should have a lawyer. And the child's views in their own cases must be made known to the court if the child so wishes. In custody disputes between parents, our drafting group is calling upon judges to carefully weigh a set of factors that place children at great vulnerability and trauma in high conflict parental custody disputes. We also want judges to exercise their authority to appoint a lawyer for the child based on the careful application of those criteria. Lawyers appointed for children must have explicit guidance on their role and this clarification of the functions of an attorney appointed by the court to represent a child is at the core of our developing model state law. Probably my greatest disagreement with the way Professor Guggenheim characterizes the work of children's advocates is in his use of an old parable. He claims children's rights advocates are grabbing drowning babies out of the river without going upstream to see who is throwing them in. That generalization is definitely not true of pediatric lawyers that I've known across the country, or those who, since 1995, have been responsible for 35 federal and state child welfare class action lawsuits. Each of these lawsuits have focused in different ways on going upstream and correcting the systemic problems that lead to too many children entering foster care unnecessarily and remaining in foster care inappropriately. Do child advocate lawyers believe that poor families need access to better paying jobs, safer housing, good child care, and well-functioning schools? Of course. Would such access help prevent child abuse, neglect, and foster care placement? Definitely. My center has recently analyzed consent decrees, settlement agreements, and court orders in 35 class action court cases. This child advocacy litigation has led to significant reforms in the expanded provision of family preservation services and medical, mental health, and social services to maltreated children and their families. These cases have helped bring major improvements to foster parent recruitment and training, protective services investigations, caseload controls, and enhanced training and supervision for child protective caseworkers. They have also led to structural reforms that enhance data collection and analysis, as well as new quality assurance activities by child welfare agencies. Many children's advocates, including the efforts of my center colleagues in Washington, actively work to get child welfare agencies to avoid unnecessary and unnecessarily prolonged foster placements altogether by offering parents services needed to keep children safe in their own homes. For those children's advocates, enhancing family support is a core children's rights issue. Just as it is too simplistic to label attorney advocates for children as anti-parent, so too is it wrong to blame child and family attorney specialists with the increased number of children enmeshed in legal proceedings. We've become a more contentious and litigative society, and our domestic relations and child welfare laws in America have become more focused on protecting the rights of adults as well as children when their cases and controversies are handled by the courts. On page 247 of his book, Professor Guggenheim states that, quote, in the topsy-turvy world of children's rights, unquote, children's rights have the opposite effect of delineating the power of state officials. Instead, he says, they expand government power. But the children's legal advocates that I know are not seeking a diminution of parental rights, but rather the reduction of trauma to children who are involved in court proceedings. For example, child advocates are promoting mediated resolutions of cases to help avoid bitterly protracted litigation. Children's legal work is also speeding resolution of children's cases and limiting unnecessary involvement of the state in children's lives. It is, I strongly believe, immoral for government to intervene in the lives of families when it fails to provide the services needed to help them care for their young children. And it is equally immoral for government to simply lock up all but the most violent juvenile offenders without giving troubled pre-delinquent youth and their families the help they need to prevent a youth's later antisocial behavior. Neither the CRC nor appropriate judicial application of the best interests of the child principle, nor anything that American pediatric lawyers are doing is likely to legally disadvantage parents if fathers and mothers are provided with the resources to keep their children safe. Nor should we fear that a more child-focused set of laws and agency services that the CRC encourages will deprive young people or parents of due process of law. In closing, I must note that the CRC provides a set of international norms to guide in closing, I must note that the CRC provides a set of international norms to guide efforts of all who work with children, not just the nations that ratify it. When I was on the United States Advisory Board on Child Abuse and Neglect, we wrote that the CRC should immediately be used as guiding principles for the work of state and local child protection agencies. Today, many of our state and federal laws conform to both the spirit and the letter of the CRC. That needs to be better known. But Americans also need to know that we have a long way to go. Whether we ratify it soon or not, the CRC must be used now in America as a tool to help provide an even stronger basis for addressing the safety and overall well-being of Americans' children. Thank you very much.
Well, I want to compliment all three speakers. You had time to spare. In consequence of the fact that you didn't use all of your allotted time, we have even more time for questions from the audience. I'm told there are microphones in the audience and that anyone who would want to ask a question should go to one of the mics. And please begin by indicating to whom your question is addressed, which of our speakers. But before we begin that process, I didn't have the pleasure of being at the panel earlier this morning, and I discerned that you are Martin Guggenheim. Is that correct? Sitting in the second row with a remarkably calm expression on his face. And I wondered whether our audience might not be interested in hearing, since we just heard from Howard Davidson, hearing your thoughts briefly in response to those comments to make the issue sharper before we go to the audience for questions. So would you like to, we have something you could, come on up.
I've known Howard for all of the 26 years that he's been at the American Bar Association. I'm not sure I ever heard him as passionate as today. And maybe I wish he didn't display that remarkable passion. But I think just as I may have surprised him happily with my support for the convention, I will say that I am very pleasantly surprised at the degree of our agreement over what is required of excellent lawyering for children. If we have a disagreement, it would be over the history of the Children's Rights Bar. And to clarify for Howard and the audience who I was thinking of in writing this book, it is the Legal Aid Society, the Guardian Ad Litem program, the offices. In New York City, it's the Juvenile Rights Division. Throughout the country, there are many offices assigned by the state the task of representing children in child protection proceedings. And over my career, I have heard no lawyers from those offices speak even partially as eloquently as Howard did today of the need for lawyers for children to go beyond what the state defines as the appropriate inquiry when parents or families are failing their own children. And to the extent that Howard has made a brilliant call for lawyers for children to begin doing that, or to the extent he is saying, I'm wrong, and they've been doing that, I'm surprised that I would be wrong about the history, but I think what's most important is that we do share the same vision of social justice for children in America.
Thank you. We have someone to ask a question. Yes? And again, please indicate at the beginning to whom your question is addressed.
Hi, my name is Terry Harris, and I'm a third-year law student here at Emory. And I have an extreme interest in educational law, so this question is directed toward Professor Jenkins. Looking at the fact that the United States does not recognize a federal right to education, it seems that we have a chicken or the egg issue as to the ratification of the CRC. It seems that it would be that we could either ratify the CRC and then promote a federal right to education, or we could promote a federal right to education and then be able to ratify the CRC. So how do you see this issue, and how do you see as the best way to go about ratifying the CRC and promoting a federal right to education?
U.S. policy pretty much takes the approach that we try to get domestic policy consistent with international human rights agreements before we ratify them. So there have to be changes within American law before we would ratify it. I actually think that is the more effective approach than waiting till afterwards, in part because I think a little bit of what we heard yesterday is that while sometimes ratification acts as a catalyst to further encourage further action, I think sometimes it can remain a little bit dormant and not generate the changes that are necessary. So I actually think it's effective to go ahead and look at domestic law and see how can we get to where the CRC is pointing us, and then make those changes and then ratify. So that's.
Might you not even say that ratification first makes it more difficult to reform, because then those in our society who oppose outside interference, who oppose our genuflecting before international norms, conceivably have a rallying point, because if we're perceived as doing something under the pressure of international norms that are not our own, that can mobilize certain constituencies in our society. So it may be better. I say this based on my familiarity with the history of international human rights documents since the end of World War II and the United States foreign policy. Any other questions? Well, I have I hope while I have a question, I'm sorry. I apologize. Yes, but we need I'm looking for the microphone going there. Great.
Thank you. International Connection Fellow from the Republic of Georgia, Georg Lilashvili. My question is to Professor Van der Waar. I want to ask you about how important is the role of religion, the religion factor in the process of growing a child, and what do you advise to future fathers and mothers while mentoring and while taking guidance to their child? Do they have to teach them in the early years of their childhood to their children the Bible or Quran, and how do you advise? Thank you.
The rights of the child to religion is guaranteed freedom of religion is guaranteed in the Children's Convention. But the Children's Convention and other international instruments also lay great stress on the family environment and parental guidance. The philosophy of the Children's Convention is that the views of the child must increasingly be taken into account as the child develops in years. So, as was said often, you will not expect a 5-year-old child to decide for herself what church they want to belong to. But as the child grows older, the parents have to respect the opinion of that child and make sure that the child is not constrained in the exercise of a responsible choice once he has reached an age upon which he can take a responsible choice. And I elaborate on this because, as I understand, the so-called religious right objects to the ratification of the Children's Convention because it undermines the authority of parents. And for that reason, I have specially looked not only at the Convention on the Rights of the Child, but also other instruments that in international law always emphasize the extreme importance of the family environment and parental control and guidance, but at the same time do not want parental guidance to undermine the dignity and the personality of the child as such.
Any other questions? We certainly have time for some more questions. Here's someone right here, if we can have a microphone.
I have a microphone. Can I go ahead?
Go. I'm sorry.
My name is Olga Jarrett.
And thank you.
I am involved in an organization called the International Association for the Child's Right to Play, which has been trying to support Article 31, the child's right to play and leisure. I understand that that was part of that article was against children being forced to work and not having any time to leisure. But I think an issue in this country is the lack of time for even recess in school. I was part of an effort to try to get a law passed in Georgia to mandate recess. I wondered if any of you would like to comment on Article 31.
Yeah. No, I think that this is a serious problem. It's one that's discussed often within the education community, and the concern being that No Child Left Behind, increasing the testing requirements every year, has sort of cut into other activities, whether it's recess or the arts or things like that. And I think that with these kind of changes in trying to achieve high standards, I think we've lost what the CRC recognizes, which is a holistic approach to the child. It doesn't just say we want to develop the child's mental abilities to their fullest potential. It talks about developing the child's physical abilities as well as their interpersonal skills. And so this notion that focusing on testing or high standards is the sole purpose of education, I think is a mistake. And I think that the CRC actually got it right in the sense that it embraces a very holistic view of the child. And I think that's one that can further not only benefit the child, but also helps them in what we've decided to focus on, which is just their mental abilities. So I think that the CRC actually got it right, and the U.S. would be wise to recognize that difference.
Can I just add to that a few days ago I was driving in my car and listened to the radio, and they were talking about the inauguration of a new residential shopping place somewhere in Atlanta, and I don't know where it was, and which I believe is a wonderful architectural and other nice place. And they had an interview with one of the young couples that live there, and what she said, it's such a wonderful place to live, but her only objection is there are no playgrounds for children.
I wanted to respond to that in connection with something the children's lawyers I know have been involved with related to kids in foster care. One of the problems when kids go in the foster care system is, for example, when a school holds a field trip, there's the issue of signing for permissions. When kids want to get driver's licenses, there's the signing approval of that. The restrictions on kids who are in the care of the state from being able to live a normal childhood existence, and that includes leisure activities, that includes recreational activities, joining sports teams and things like that. They should not have any barriers imposed because they're wards of the state. And I know that lawyers have intervened to help assure in various places around the country that children in foster care are not second-class citizens when it comes to participation in athletics or school field trips or other opportunities that all children should have.
Yes, sir.
Hi, I wanted to ask a follow-up to the question of how you balance the child's freedom to choose their own faith with the parent's role. And you said that as the child got older, they had more room to make their own choices, if I understood your what you said about that. I was curious if you could make that more concrete. At what age could a child say to their parents, I no longer am of the religious faith that we have been, I choose to go to a different religious service? You have no authority over that choice.
Yeah, the Children's Convention does not lay down an age restriction. Okay. They just lay down the principle that the children's views must be taken into account depending on his stage of development. And this does not mean that a child can necessarily disobey his parents, but if I could just use one concrete case, which is one of the South African cases that is in my paper. There was a recent case in which the Supreme Court was called upon to endorse a divorce settlement between husband and wife who had a 3-year-old kid. And one of the terms of the settlement was that the custodial parent will bring up the child within the apostolic faith mission and secure that the child will attend all religious functions and participate in religious services. The court refused to make that an order of court because they said that puts upon the parent an obligation to compel the child irrespective of the age of the child, and so they wouldn't, the court would not confirm that. Based on the Children's Convention, by the way.
Let me make we are now 12:15 at the moment at which the session is supposed to end. Let me make an announcement before that happens, though. There is something in the lobby that if you're interested in signing, you can sign. If you would like to, I'll read this. If you would like to join the campaign for U.S. ratification of the UN Convention on the Rights of the Child, you can provide your name, phone number, email address on a sign-up sheet in the lobby, and you'll be contacted about that. I want to thank Kimberly, Johan, and Howard very much for a stimulating session. Thank all of you for being here, and hope you'll be back this afternoon. Thanks very much.
The preceding program is copyrighted by Emory University.